But is he currently under prescribed medication?
I've been taking Adderall since I was 7 years old, so it took 30 years. And this whole incident got me, a doctor cut me off cold turkey just because of this whole thing, but I still had some
The
left.
doctor cut you off, so you shouldn't have been taking it. I know it's going to be hard for you to respond because, gee, there's no client. The one that I told not to leave the courtroom.
That's
But
right.
I'll let you go ahead.
Clerk calls the case of the people versus Martz Richard.
Is that on behalf of the people, Your Honor?
And Laura Yagi, Assistant Public Defender, with and on behalf of Mr. Richard, who's approaching counsel's table. Can you state your name for the court? And sorry.
Martz Richard.
And you're, sorry, Your Honor, there are two matters here. We do have discovery in one, but unfortunately, I believe there's outstanding discovery in the second. So we would be asking for a brief adjournment to obtain that discovery, continued discussions.
And that's correct, Your Honor. I did request that discovery in that case yesterday, and if we could be heard on bond as well.
All right. But you're requesting discovery on both cases or an adjournment on both cases?
I am.
Probable cause conference will be adjourned March 20th, 2025, 9 a.m. As to bond.
Your Honor, we were informed this morning by the victim that the defendant, when he was in custody, check this, he did try to call her number 6 times from jail when he was in custody. And since release, he's been trying to contact her by call, text, and Facebook. She has not answered, and she did file a police report with, was it YPD? With YPD, and so that could be future charges coming because of that.
Response?
Yes, Your Honor. So first of all, this is the first I'm hearing of this. I don't know whether the calls were made before or after the arraignment. Obviously, I think that's really crucial to know if the calls were made before he was told not to have contact with her or not. This is someone he's had a relationship with for 14 years. He has 4 children, this person, they've had kind of an off and on relationship for the past few months, but my understanding is she saw on Facebook that he was dating another woman and got very angry recently. Obviously, I would ask the court to continue his bond, obviously continue the no contact order until, and potentially even set this for bond violation on the 20th, but until we have further information about what that bond violation is, until we have the police report or until we have information that the jail calls were made after his arraignment. My understanding is he was given a PR and released pretty quickly after. So again, I don't know, but it's very possible those calls were made before he was actually told by the court not to have contact with her. And we haven't been presented any evidence whatsoever of the actual communication or attempted communication. So until that time, I would ask that the court continue his bond.
Also, I got my job. I'm supposed to be at work.
Okay. And the other thing is Mr. Richard is a manager still at Burger King, right? And he just got a new apartment. He had been working on getting this apartment through his caseworker for like 8 months, and he just moved into that new apartment. And I know he was extremely concerned about losing that apartment if he loses his job, which would, of course, be at risk if he was to be incarcerated.
And I've been homeless for 7 months.
Check the dates on the attempted calls from the jail.
All right. Well, here's what I'll do. I'll pass it momentarily, let them check the dates, compare them to the arraignment, make a good point in regard to that. But there are also other calls.
Yes, the victim informed us that he's been trying to text, call, and connect with her on Facebook multiple times. So she did file a police report on those.
On those things. Do we have a copy of that report?
Not yet. I believe she filed it yesterday, so we haven't received it yet.
Can somebody try to call over to YPD and see if that report's right? Just make the call. Please. I think I know what the answer is, but whatever. All right, I'm going to pass it, sir. You're not to leave the court.
Your Honor, I got my job.
Sir?
Because we don't even know what's going on. So just grab those 2 files.
Buckle up, Guys, today we're stepping inside a courtroom where a routine hearing suddenly begins raising serious concerns. What starts with legal discussions over discovery quickly shifts when prosecutors reveal allegations that the defendant repeatedly contacted the alleged victim despite being in custody and after his release. The defense pushes back, arguing there's no verified proof yet, while the judge pauses to verify the facts. Just when it seems like the hearing will continue normally, the judge gives one clear instruction that will soon change everything.
From the victim screenshots, and some of those were from as recently as I think March 1st, as from the defendant.
And certainly after the date of arraignment.
Yes.
Jackie, I know it's gonna be hard for you to respond because, gee, there's no client. The one that I told not to leave the courtroom,
That's
but
right.
I'll let you go ahead.
I haven't seen what the prosecutor is referring to. Obviously, I would ask if the court would consider setting the bond violation hearing for the 20th. And my client was eager to make some calls. I have no representations as to his whereabouts.
Well, and we were kind of informed that he had left the courtroom, so just so that the record is clear, and I had told him not to, that I had personnel check to see if he were still here or had just gone to the restroom or whatever, and he was not here at all, and had indeed left after being told by the court not to leave. So we will not be adjourning the probable cause because he's not here. He decided to he's here and left. So a bench warrant will issue in both of these cases for defendant's failure to appear based upon his leaving as well as the preliminary representation to the people. No bond on both of these matters. Don't know where he thinks this is going to get him. And that warrant will issue immediately. And I think these are YPD cases. They are. So after we get that warrant issued, if you could ask the officers over there. Court does call the case People versus Andrew Party. Key cases.
Conrad Siller on behalf of Pittsfield Township in both cases.
Good morning, I'm Charlotte Steffen on behalf of Andrew Party. Andrew, you say your name?
Andrew Party?
Assistant Public Defender Natalie Tate on behalf of Andrew Party, still on the case ending in, 1090.
Got it.
You are?
All right.
I apologize, Your Honor. I believe Ms. Steffen has been appointed to both cases. Is that correct? That was my understanding, Your Honor, but maybe I'm mistaken.
You have that?
I'm double checking.
Because I don't.
So I have her on case ending in 0621.
Correct.
And then PD.
Yeah. So he has two attorneys.
All right, guys, the courtroom picks up exactly where the tension left off. But this time the stakes rise dramatically. Prosecutors return with updates pointing to fresh evidence of contact after the defendant's release, while the defense struggles to respond because something unexpected has happened. The defendant has ignored the judge's direct order and walked out of courtroom. In a matter of seconds, what could have been a routine bond discussion turns into an immediate bench warrant with no bond, proving that one decision can completely change the course of a criminal case.
It would be a month and a half long period.
Yeah. That's a lot of amphetamines that he was in possession of. If what he's indicating to you, counsel, is true, Mr. Allen.
I have about 10 more left in my script.
There's also a cocaine positive test. On
Yeah, I mean,
October, yeah.
Yeah, it was in August 26th. Does he have an explanation for that?
No, Your Honor, he's denying use of cocaine.
He's denying the use of cocaine.
Yes, Your Honor.
So he wants a hearing on that.
Yes, Your Honor.
But he admits to the use of amphetamine without a valid prescription.
I had a scripture. I don't know what you're talking about. I mean, I don't have one. I don't have it with me here.
Is the amphetamine a prescribed medication that he's currently under prescription for?
So Judge, I think that the issue is that Mr. Party is saying that he was prescribed the medication.
They just cut
I
me
don't know
off
how old the prescription was. These were some pills that he was still in possession of from a prescription.
a couple months ago.
But is he currently under prescribed medication?
I've been taking Adderall since I was 7 years old. So it took 30 years. And this whole incident got me, my doctor cut me off cold turkey. It's just because of this whole thing, but I still had some
The
left.
doctor cut you off, so you shouldn't have been taking it.
Not because of that. He doesn't want to be my doctor anymore. I'm not gonna. I got the paperwork. I'll send it to you. I got this guy right now.
Okay, just so that I'm clear, I thought we were talking about an old prescription.
It is. Which
So
mom,
when did your doctor cut you off?
couple months ago. It's more like he just stopped being my doctor. You know, got into a thing, and it's just now I have to get a new doctor, CMH, and they're telling me I'm like weeks out. It's not easy trying to get back in.
Let's
I had to
try
go
it
through
this
counseling.
Let's try it this way. When's the last time you filled that prescription?
It's a couple months ago. And I had my mom hold on to my pills while I was homeless for the time being. Now that I'm back to work and everything else, I'd gotten back on them. I wasn't gonna wait till I started school again. It's not easy carrying those around. People keep stealing them. So yeah, I'd have my mom hold on to them. I feel like that's not a problem. I keep it at the house. I don't got a home.
What are we doing with the cases? I'll address this bond.
Your Honor, we are asking for an adjournment. We received some additional discovery yesterday, so we need some more time to review.
That's right.
I was going to be requesting an adjournment as well, Your Honor.
Witness matter to my next date of October 15th, 2025 at 9 on both cases yes, the case ending. Ms. Stephens on which case? All right. Now in that case, I'll set a bond hearing, or I'll set a bond violation hearing. Regarding the use of cocaine for that same date of October 15th, 2025. I'll set that at 9 a.m. So he's not sure I quite understand, but I've got this cocaine in between the use of the amphetamines. Also, he didn't receive, he's indicating kind of the same thing, that he's on some prescription. This might have been avoided if it's indeed true. That he says he's currently on prescription, but then didn't provide documentation to community corrections. When community corrections then checked through their system, he's not currently prescribed a medication that would test positive for amphetamines.
Talking about the intake?
So if he's indicating that he gave that prescription to his mom or that prescription does indeed exist, then he should have been able to provide it to community corrections and he should have been able to provide it to the court. What I'm going to do at this time is defendant's bond is defendant's remanded. Counsel, if you can get that information from the court, then I'll reconsider that. Thank
See
you.
what I can do, Your Honor. Thank you.
All right, guys, the next hearing shows that courtroom credibility can be just as important as the charges themselves. A defendant tries to explain why amphetamines appeared in his drug test by pointing to an old prescription, but the judge keeps pressing for one thing: documentation. As questions continue, another positive result for cocaine only deepens the court's concerns. Without evidence to support his claims, the judge decides caution comes first and orders him back into custody, reminding everyone that explanations alone rarely outweigh proof.
Bill Davis.
I spell this for people.
Rob Brunting on behalf of Mr. Davis, Your Honor.
You're good. You're good. Okay. You can cancel that.
Yeah, I'm requesting a short adjournment in this case. There's several other matters pending and we'd like to do it global.
Give you my next date, October 15th, 2025, 9 a.m.
Thank you.
Bond continued. Thank you.
Your Honor, would you consider a release to treatment if he,
If they send over the order for release to treatment, I don't have a problem with signing that.
that's what you want?
Yes, sir.
What makes these courtroom moments so compelling is that neither defendant was facing a final verdict yet. Both were dealing with something that often determines the direction of a criminal case long before trial, whether the court believes they can be trusted to follow its orders. In Martz Richard's case, everything changed when allegations surfaced that he violated a no-contact order, and then the situation became dramatically worse when he left the courtroom after the judge explicitly instructed him to stay. That single decision transformed what could have been a routine adjournment into an immediate bench warrant with no bond. Meanwhile, Andrew Carty's hearing demonstrates a different, but equally important lesson. Bond conditions aren't optional, and when drug test results conflict with a defendant's explanation, judges expect clear documentation, not just verbal assurances. Without proof to support his claims, the court chose caution over trust and ordered him remanded into custody pending further review. Together, these cases show that courtroom behavior, compliance with bond conditions, and credibility can carry just as much weight as the underlying charges themselves. A judge is constantly evaluating whether a defendant respects the court's authority, and even seemingly small decisions can have major legal consequences.
All right, guys, these final courtroom moments tie both cases together with a lesson every defendant should understand. Neither hearing ended with a final verdict, yet both were shaped by decisions made long before trial. One defendant lost his freedom after ignoring the court's instructions, while the other couldn't support his explanation with evidence. In court, credibility, compliance, and respect for judicial orders often influence the outcome as much as the charges themselves. If you enjoyed this courtroom breakdown, don't forget to like this video, subscribe to the channel, and turn on notifications for more real courtroom analysis. Thanks for watching, and we'll see you in the next video.